Hi, I'm Abhinav, Associate Partner at Krishnamurthy and Company. We are a full-service law firm headquartered in Bangalore. We assist a lot of startups in their endeavor to raise early-stage funding, as well as the Series A funding, Series B funding, and going forward, we do a lot of M&A transactions. We are here to discuss a few important terms of an investment term sheet that we come across in all the deals that we assist either the startups or the investors. So once a startup has received interest, a term sheet is signed. A term sheet is nothing but a summary of what is going to be elaborated in your shareholders' agreements. It will detail all the rights that the investor is looking for. It will also detail all, not detail, but in a summary, provide for the rights that the investor is looking for, and it will also provide a summary of the obligations that the promoter, the founder, is going to be taking going forward. Once the term sheet is signed, the investors will generally start a due diligence process on the company. The due diligence could be on various fronts. There'll be a legal due diligence, there'll be financial due diligence, there could be a technical due diligence if the investor deems fit. Once the due diligence exercise is over, there is the shareholders agreement, which is nothing but an elaborate form of what is agreed in the term sheet. So just taking a step back, it is that's a reason, and one reason why it is very important to be vigilant at the time of signing the term sheet is you need to understand that once you've signed the term sheet and you've gone to the shareholders agreement, there is very little that you can change, though the term sheet is going to be a non-binding document. But in principle, an agreement has been reached between a promoter and the investor. So while you are negotiating the term sheet, make sure that you've covered everything to your satisfaction. Speak to your lawyers. Don't sign a term sheet without consulting either with a lawyer or someone who's been in the ecosystem for a long time, who understands the term sheet. Do not think that there is going to be a detailed agreement in the future which can be renegotiated and terms in the term sheet can be changed. It doesn't generally happen, and then the investor is not going to like it. So once the diligence process is over, the investor generally will send a draft of the shareholders agreement, which more or less will be on the lines of what was agreed under the term sheet, just a detailed form of it. The shareholders agreement will also have a clause which is commonly known as conditions precedent to closing, and which covers most of the aspects that have come out of the due diligence exercise that the investors advisors would have undertaken. It could be anything. The company may not have taken certain licenses. There could be certain things missing in its financial bookkeeping. So all these things need to be rectified. They're more or less like housekeeping activities. Once the shareholders agreement is agreed to between all parties, it is signed, and then the promoters and the company, they move on to completing all conditions precedent to closing. Once all the conditions precedent to closings are completed to the satisfaction of the investors, of course, the investor will go ahead, wire the money into the company's bank account, and then there are various secretarial activities that need to be undertaken to allot the shares, to appoint the directors, to amend the charter documents of the company in line with what is agreed into the shareholders agreement. The next point that we can discuss is the board composition that an investor would typically look for while investing. In our experience, we have seen that investors, while investing, would look for one board seat along with, not always, but sometimes, one board observer seat. Now, what is a board seat and what is a board observer seat? A board seat allows the investor to appoint one of its nominee directors on the board of the company, who can attend all the board meetings, vote at the board meetings, while a board observer is appointed generally to only attend board meetings, evaluate what is happening at a board meeting, keep a tab on what are the matters that were discussed and what was discussed at the board meeting. Along with taking a board seat, because an investor is always going to be, or at least most of the times is going to be, a minority shareholder of the company, the investor would look for certain affirmative voting rights, also known as veto rights. So it's a list of matters which are very critical for the functioning of a company, which has a lot of monetary impact on the company. These matters will always be subject to an affirmative vote from an investor director. So what it means is, while an investor director cannot pass a resolution on its own or on his own by virtue of him not being in majority, either on the board or at the general meeting of the company, at the meeting of the shareholders of the company, he will have a right to provide affirmative vote on these matters. So while he has the right to block a matter, an investor who is in minority will never have a right to get a matter passed unilaterally. And that is why a list of affirmative matters is so critical for an investor while he is investing in a company. Another important aspect that an investor looks for while investing is what is going to be reserved in the cap table of the company, what is going to be reserved for the employees. Employee stock option pool, as we all know, has been a very important and a very handy tool for employee retention in all companies in India, and specifically startups. There are various reasons why you would need to have ESOPs, and more particularly a certain amount of shares reserved for issuance to employees as ESOP. Now, how do you decide the quantum of pool, and the percentage of pool may just vary from company to company depending on what the employee base is, what is it that the promoters are comfortable parting away with employees, and how much are they comfortable diluting themselves, because they're diluting themselves because of the investment also. The other thing that we can discuss is the kind of instruments that are typically issued to the investors. Typically in an investment transaction, you would see that an investor would look for a mix of preference shares and equity shares. Preference shares will always be in the nature of compulsorily convertible preference shares, because they convert only into equity and cannot be redeemed. To say the investor cannot go back to the company and return the preference shares and take the money out. It doesn't act like a debt. It's a compulsorily convertible preference share which necessarily converts into equity. Now, why are these two instruments different, and why do investors look for a mix of both these instruments? Equity shares, by its very nature, and more popularly known as common shares in the West, common stock in the West, carry voting rights and other common shares, so do not have any superiority when compared to other instruments of the company. So they are at the bottom of the ladder, while preference shares are superior to equity shares, and they carry preference in certain aspects of how they have to be treated. One example is a liquidation preference. Preference shares naturally by their nature would carry preference over equity shares. So why do investors take preference shares? One reason is because they are superior to equity, and it gives an investor the comfort that they would be able to take their money out of the company in case of a liquidation prior to the equity shareholders being able to do so. Why do investors also take equity? So that the investors can exercise their voting rights in the company. As per the laws of India, the Companies Act, which really governs how equity and preference shares have to be dealt with, uh, equity shares will carry votes. However, preference shares do not carry voting rights. So that's about equity shares and preference shares. Another difference, another aspect where preference share can be superior to equity share uh, is when it comes to receiving dividends in a company. So when a company declares dividends, it will first give it to the preference shares because it's got preference over equity shares. And preference shares can also receive dividends at a fixed rate, at a fixed coupon rate, which does not happen with equity shares. The next topic that we can discuss is anti-dilution and the various mechanisms that investors look for while ensuring an anti-dilution protection. So what is anti-dilution? When an investor puts his money in the company, it is done at a certain valuation. After the investment is completed, after the company is exhausted that investment amount, the company may need further funding in the future and may look at other sources of investment or other investors to raise more money. Now, there may be a situation where the company is not being able to raise funds at the same valuation, and the valuations dropped below what it was when the first investor put his money in. So in that situation, what practically happens is the value of the first investor's money has gone down. It's gone down to what the next round's investment value is. To protect this, to protect the downside, an investor looks for an anti-dilution protection. Now, anti-dilution protection can be exercised in various manners. One of them is a full ratchet. In a full ratchet, if an investment transaction, if the subsequent investment transaction has happened at a lower valuation, the investor would seek such additional number of shares in the company, or if the investor has taken a convertible instrument, then would seek such adjustment to the conversion price of the instrument, which would enable the investor to go down to the value of the current round. So just to give an example, if an investor had invested at a valuation of $1 million and the subsequent round has happened at, say, $750,000, the previous investor should be entitled to get such number of shares that the value of his investment comes down to $750,000. However, there are other mechanisms that investors also adopt to ensure an anti-dilution protection. One of them being broad-based weighted average mechanism, which is the most popular mechanism as of today, from my experience. In a broad-based weighted average, the valuation of the first investor is not adjusted down to the subsequent round's valuation, but it is adjusted down to an average of the last round's valuation and the current round's valuation. Just to put it in a very, very layman's language, it's an average of the two rounds. So it is not as detrimental to the interests of the promoters, because in a ratchet where the valuation has to go down to the current round's valuation, in a broad-based weighted average, it only comes to the average of the last round and the current round's valuation. To go into the details of a participating and non-participating liquidation preference, I think it is more important to first understand what liquidation preference is. Liquidation preference is a right which entitles the right holder to receive his or her investment back in a company prior to any other shareholder of the company. So for example, if an investor has invested certain amounts in a startup, at the time of liquidation, which could be by way of an acquisition, a winding up, a sale of assets, the investor will have the right to receive the money before any other shareholder of the company does. Now, what is participating and non-participating liquidation preference? Participating liquidation preference allows the investor to first take his investment amount or such multiple of the investment amount out of the company as may be agreed with the founders and the other shareholders. After that amount's been taken out, whatever remains is distributed amongst all the shareholders, including the investor, pro rata to his shareholding in the company. So, for example, if the investor holds 10% in the company, he will be entitled to take out 10% of what remains after the liquidation, after he's received his liquidation preference. A non-participating liquidation preference, on the other hand, does not entitle the investor to dip into what remains after he's taken his liquidation preference. So to just elaborate by way of an example, in case of a liquidation event, in a non-participating liquidation preference, the investor will either take his investment amount or such multiple of his investment amount as may be agreed, or the pro rata portion in the total amount that the company receives as a part of the liquidation. In a nutshell, this is the difference between a participating and a non-participating liquidation preference. From an investor's perspective, it would always be beneficial for the investor to take a participating liquidation preference, while from a founder's perspective, it would always be better that the investor takes a non-participating liquidation preference.